Hi, this is Terry Babcock with Real Estate Consulting, LLC. I'm going to be making a series of videos to celebrate the 50th anniversary of the Florida Land Trust Act to help educate the public and promote its use. The Land Trust was first created in England at the time of Henry VIII and is now over 468 years old, and is one of the finest tools for real estate ownership and management ever conceived of, and has been in the United States for over 100 years. It was perfected by the Chicago Title Company in Chicago, Illinois. The Florida Land Trust Act was created in 1963. Unfortunately, most real estate attorneys and realtors don't know about land trust, just like most people don't know you can buy real estate in your self-directed IRA and keep all the profits from the deal 100% tax-free. It is my goal to bring this information to the masses. I firmly believe that every piece of real estate should be held in a Florida land trust. Before we get started, please allow me to cover my assets and read the following blanket disclaimer. By watching this video, you agree, acknowledge, and understand that this video and all the opinions expressed herein by its authors are not to be considered professional advice. Nothing contained herein should be construed as legal and/or accounting advice, and it is strongly advised and encouraged that you consult with your own legal and accounting professional before utilizing any of this information. You are solely responsible for the use of these concepts and ideas, opinions, and content contained herein, and agree to hold Real Estate Consulting, LLC, and all its members, successors, assigns, and affiliates completely harmless in any event or claim. Again, I am not an attorney, nor should any advice that I might offer be construed as legal advice. The assistance of competent legal counsel is always recommended. With that being said, let's go right to the source. On the screen we have the Florida Senate's website. If we go up here, let me highlight this for you. It's flsenate.gov/laws/statutes/2013/chapter 689, and that is the conveyances of land and declarations of trust. Now I'd like you to go back. I'm only going to show a little bit of this, but you can click on, I want you to read all of these sections, and they're mostly pretty short. There's a couple of paragraphs in general. You can see, I mean, that's a paragraph. I'm going to skip down here to the actual Florida Land Trust Act. And we're going to click on that, and here's where you're going to want to read. Now, I took and copied this to a Word document so I could highlight areas I wanted to go over with you, and you can go back to the website and read the rest on your own time. Okay, here we have my Word document that I copied, and so I could highlight the sections I want to go over with you. Let's see right here. A, beneficial interest means any interest, vested or contingent, and regardless of how small or minimal each interest may be in a land trust, which is held by a beneficiary. Beneficiary means any person or entity having a beneficial interest in a land trust. A trustee may be a beneficiary of the land trust for which such trustee serves as trustee. This means that you can be the trustee and the beneficiary of the same trust. Land trust means any express written agreement or arrangement by which a use, confidence, or trust is declared of any land or of any charge upon land under which the title to real property, including but not limited to a leasehold or mortgage interest, is vested in a trustee by a recorded instrument that confers on the trustee the power and authority prescribed in section 689.073, and under which the trustee has no duties other than the following. So these are the trustee's duties: the duty to convey, sell, lease, mortgage, or deal with the trust property, or to exercise such other powers concerning the trust property as may be provided in the recorded instrument, the land trust agreement. In each case, as directed by the beneficiaries or by the holder of power of direction. Number 2, the duty to sell or dispose of the trust property at the termination of the trust. Number 3, the duty to perform ministerial and administrative functions delegated to the trustee in the trust agreement or by the beneficiaries or the holder of power of direction. Number 4 is about timeshares. Don't really care much about timeshares, so let me scroll down. D, power of direction, means the authority of a person as provided in the trust agreement to direct the trustee of a land trust to convey property or interest, execute a lease or mortgage, distribute proceeds of the sale or financing, and execute documents incidental to the administration of a land trust. Now, this is important because you don't want to have to pay your trustee, who's hopefully going to be a lawyer, a lot of money to do all this stuff when you can do it yourself, just by assigning yourself as power of direction in the trust agreement. So you definitely want to do that. Let's scroll down a little bit. Trust property means any interest in real property, including but not limited to a leasehold or mortgage interest, conveyed by a recorded instrument to a trustee of a land trust or other trust. Trustee means the person designated in a recorded instrument or trust agreement to hold title to the trust property of a land trust or other trust. Let's go down. Statute of uses is inapplicable. This is very good for us. Section 689.09 and the statute of uses do not execute a land trust or vest the trust property in the beneficiary or beneficiaries of the land trust, notwithstanding any lack of duties on part of the trustee or otherwise passive nature of the land trust. See, doctrine of merger is inapplicable. The doctrine of merger does not extinguish a land trust or vest the trust property in the beneficiary or beneficiaries of the land trust, regardless of whether the trustee is the sole beneficiary of the trust. So again, you can be the trustee and the beneficiary of the same trust, if you so choose. I would only recommend it for a short term if you're buying houses and flipping the house, doing a short sale, something like that, where you're a trustee for a short time, and then you just assign your trustee over to your end buyer's trustee. Personal property. This is new. In all cases in which the recorded instrument or the trust agreement is hereinabove provided contains a provision defining and declaring the interest of beneficiaries of a land trust to be personal property only. Such provision is controlling for all purposes when such determination becomes an issue under the laws or in the courts of this state. If no such personal property designation appears in the recorded instrument or in the trust agreement, the interests of the land trust beneficiaries are real property. So basically this is simply saying that in the previous version, beneficial interest was personal property. In the new statutes, it says you have to choose between personal or real property. If you don't put down personal property, it defaults to real property. And most of the benefits of the land trust are the fact that it is personal property. So you're going to need to talk to an advisor about which way to go there. Land trust beneficiaries. Except as provided in this section, the beneficiaries of a land trust are not liable solely by being beneficiaries under a judgment, decree, or order of court, or in any other manner for a debt obligation or liability of the land trust. Any beneficiary acting under the trust agreement of a land trust is not liable to the land trust trustee or any other beneficiary for the beneficiary's good faith reliance on the provisions of the trust agreement. And this is new. A beneficiary's duties and liabilities under a land trust may be expanded or restricted in a trust agreement or beneficiary agreement. I love this because it leaves for options and flexibility. I love flexibility. This is going to create even more benefits once people figure out how to best utilize B, if provided in the recorded instrument of the trust agreement or in the beneficiary agreement, a particular beneficiary may own the beneficial interest in a particular portion or parcel of the trust property of the land trust. A particular person may be the holder of the power of direction with respect to the trustee's actions concerning a particular portion or parcel of the trust property of a land trust. The beneficiaries may own specific portions or percentages of the beneficial interest in the trust property or in particular portions or parcels of the trust property of a land trust. And lastly, multiple beneficiaries may own beneficial interest in the land trust as tenants in common, joint tenants with right of survivorship, or tenants by the entireties. I love this section. It allows for a lot of flexibility. It allows for you to go in partners with people. You could buy, say, a 1 acre lot with 3 of your friends, divide it up into 4 quarter-acre lots, and each person has control over their lot. It really is great flexibility there. Let's scroll down. The perfection of a lien or security interest in a beneficial interest in the land trust does not affect, attach to, or encumber the legal or equitable title of the trustee in the trust property, and does not impair or diminish the authority of the trustee under the recorded instrument. And parties dealing with the trustee are not required to inquire into the terms of their unrecorded trust agreement or any lien or security interest against a beneficial interest in the land trust. Again, this is great. The trustee's legal and equitable title to the trust property of a land trust is separate and distinct from the beneficial interest of a beneficiary in a land trust and in the trust property. A lien, judgment, mortgage, security interest, or other encumbrance attaching to the trustee's legal and equitable title to the trust property of a land trust does not attach to the beneficial interest of any beneficiary. And any lien, judgment, mortgage, security interest, or other encumbrance against a beneficiary or beneficial interest does not attach to the legal or equitable title of the trustee to the trust property held under a land trust, unless the lien, judgment, mortgage, security interest, or other encumbrance by its terms or by operation of other law attaches to both the interest of the trustee and the interest of the beneficiary. F, the trust agreement for a land trust may provide that one or more persons have the power to direct the trustee to convey property or interest, executing mortgage, distribute proceeds of a sale or financing, and execute documents incidental to the administration of the land trust. The power of direction, unless provided otherwise in the trust agreement of the land trust, is conferred upon the holders of the power of the use and benefit of all holders of any beneficial interest in the land trust. In the absence of a provision in the trust agreement of a land trust to the contrary, the power of direction shall be in accordance with the percentage of individual ownership. In exercising the power of direction, the holders of the power of direction are presumed to act in a fiduciary capacity for the benefit of all holders of any beneficial interest in the land trust, unless otherwise provided in the trust agreement. A beneficial interest in a land trust is indefeasible, and the power of direction may not be exercised so as to alter, amend, revoke, terminate, defeat, or otherwise affect or change the enjoyment of any beneficial interest in the land trust. Wow, that was a lot. Scrolling down, the principal residence of a beneficiary shall be entitled to the homestead tax exemption, even if the homestead is held by a trustee in a land trust, provided the beneficiary qualifies for the homestead exemption under Chapter 196. Let's see, successor trustee. If the recorded instrument and the unrecorded trust agreement are silent as to the appointment of a successor trustee of a land trust in the event of the death, incapacity, resignation, or termination due to dissolution of a trustee, or if a trustee is unable to serve as trustee of a land trust, one or more persons having the power of direction may appoint a successor trustee or trustees of the land trust by filing a declaration of appointment of a successor trustee or trustees in the public records of the county in which the trust property is located. The declaration must be signed by a beneficiary or beneficiaries of the land trust and by the successor trustee or trustees. It must be acknowledged in the manner provided for the acknowledgement of deeds and must contain the following: legal description, name, address, etc. And moving on. Each successor trustee appointed with respect to a land trust is fully vested with all the estate, properties, rights, powers, trusts, duties, and obligations as the predecessor trustee, except that any successor trustee in the land trust is not under any duty to inquire into the acts or omissions of a predecessor trustee and is not liable for any act or failure to act of a predecessor trustee. Moving on, a trust agreement may provide that the trustee of a land trust, when directed to do so by the holder of the power of direction or by the beneficiaries of the land trust or legal representatives of the beneficiaries, may convey the trust property directly to another trustee on behalf of the beneficiaries or to another representative in such directive, named in such directive. And moving on. Well, that I didn't want to read, I guess. Let's see. I guess that's about it. So you can go back to the website. Oops. FloridaSenate.gov and read that on your own. Now, Mark Warda, who is the author of Land Trust in Florida and was actually on the committee that helped rewrite the statutes, is having a seminar in Tampa. This is his website, FloridaLandTrust.com, and he's definitely the trustee I would use in Florida. We're going to come down here to his on his website to seminars and lectures, and here we see Land Trust and much more seminars. The Ramada West Shore Hotel on October 12th. Let's see, click on the flyer here, let's see that. And here we go. Land Trust and much more. Personal Property Trust, LLCs, Roth IRAs, increasing your profits and more. Let's see. Learn how trust can give liability protection, structure short sale purchases, and on and on. It includes the latest edition of Mark's book, plus the CD with the forms. Also includes 2013 landlord and LLC law changes. Whoops. And let's see, pay in advance $175. That's extremely cheap. I mean, the book alone is $50. And let's see here, 8 hours of continuing education for credit, education credit for realtors, attorneys, and CPAs. I mean, guys, 8 hours of continuing education, as well as education you can utilize to help your investors and residential home buyers. Okay, so that's all for this video. I hope to see you at Mark's event. I'll see you in the next video. Thank you.